1956 provided that Chief Justice of Pakistan shall be appointed by President and other judges shall be appointed by President after consultation with the Chief Justice. With regard to the appointment of High Court judges, under Constitution of 1956, it was laid down that every judge shall be appointed by President after consultation with Chief Justice of Pakistan, Provincial Governor, to which appointment related, and if appointment is not that of Chief Justice of High Court. Constitution of Pakistan 1962 provided the Chief Justice of Pakistan shall be appointed by President and other judges shall be appointed by President after consultation with Chief Justice. Whereas Constitution of 1962 provided that High Court judge shall be appointed by President after consultation with Chief Justice of Pakistan, Governor of Pakistan, province concerned, and Chief Justice concerned, where appointment is not at that of Chief Justice. Since 1973, judicial system of Pakistan is being regulated under Article 175 of Constitution, which provides for establishment of Supreme Court and High Courts in each of the 4 provinces. Through an amendment to this article, High Court for Islamabad has also been established. Induction of High Court judges earlier was made on recommendations of respective Chief Justices after approval of Provincial Governor concerned, whereafter matter was sent to Chief Justice of Pakistan and accordingly final approval was made by President through Federal Ministry of Law. This procedure was completely changed through 18th Amendment in Constitution of Pakistan by adding Article 175A, which provided for Judicial Commission comprising of judges of Supreme Court and High Courts, Federal Minister for Law and Justice, Attorney General for Pakistan, and representative nominee of Pakistan Bar Council and Provincial Bar Council. After nomination was made by Judicial Commission, matters was referred to Parliamentary Committee consisting of 4 members from Senate of Pakistan and 4 members from National Assembly. And out of these 8 members, 4 were to be taken from Treasury benches and 4 from opposition. Committee had power either to confirm nomination made by the Judicial Commission by majority of its total membership or may not confirm nomination by 3/4 of its total membership. Now, 26th Amendment to Constitution has been promulgated, which has merged Commission and Parliamentary Committee. However, under 26th Amendment, a woman or a non-Muslim other than Member of Parliament who is qualified to be a Member of Senate as a technocrat has been added in Judicial Commission. The role of civil society has been given. After promulgation of 26th Amendment, independence of judiciary is not infringed. Independence of judiciary is obvious from the fact that tenure is fixed and a judge cannot be removed except on grounds as mentioned in Article 209 of Constitution by Supreme Judicial Council comprising of judges of Supreme Court and High Court. Similar is the case for removal of punishment of members of armed forces by courts established under the Pakistan Army Act 1952, and that also speaks about independence of institution of army. However, independence of parliamentarians is not secured. In case of inappropriate action by them, their removal or punishment is not by their own brother parliamentarians, but by judges. It is a historical fact that on false allegations which have been leveled against parliamentarians have led to the removal by judges of the past, and even governments were dismissed, and 2 prime ministers were removed through judgments of Supreme Court of Pakistan. Let us look into the mode of appointment of judges in superior courts in few other countries. In USA, justices of Supreme Court, Court of Appeal judges, and District Court judges are nominated by President and confirmed by US Senate. In Canada, justices of Supreme Court of Canada are appointed on Prime Minister's advice, and judges of provincial and territorial courts of appeal are appointed by provincial and territorial governments through judicial advisory committees, which are appointed by provincial and territorial government, in which there are nominees of government. In United Kingdom, there is a selection committee for selection process convened by the Lord Chancellor consisting of 5 members. In Australia, executive enjoys unfettered powers of judicial appointment. So, a Chief Justice holds a unique position in this evolution, not only for just interpreting laws, but also guiding judiciary through internal reforms and external pressures. Over years, each Chief Justice has left a distinct legacy, some reinforcing independence and and others, setting new constitutional precedents. Justice Qazi Faez Isa''s tenure as Chief Justice demonstrated an unwavering commitment to transparency, judicial restraint, and rule of law. His leadership exemplified a careful balance of authority, contributing significantly to strengthening democratic principles and environmental governance. One hallmark of his tenure was his minimal use of suo motu powers, in stark contrast to his predecessors, who took dozens of such notices, on one with 64 and another with 57. Justice Isa'a used his power sparingly, reflecting his philosophy of judicial restraint and rejection of judicial activism, which he saw as critical to maintaining institutional balance. He was also a vocal opponent of judicial martial law, reinforcing judiciary's role in supporting democratic governance rather than intervening politically. Justice Isa'a rectified major unconstitutional decisions, such as overturning lifetime disqualification of politicians under Article 62(1)(f) and addressing misinterpretations in Punjab government case related to Article 63(a). His correction of historical wrongs also included revisiting Zulfikar Ali Bhutto's Shahid's case, restoring dignity of judiciary and rectifying past injustices. Another important achievement was his handling of election-related matters. Justice Isa'a prioritized democratic integrity, ensuring that 2024 elections are held on schedule despite obstacles. His rulings compelled institutions to act according to law, preventing undue delay through judicial intervention. Supreme Court under Chief Justice Qazi Faez Isa'a formally resolved controversial dam fund issue by distancing judiciary from the project. Justice Isa'a ruled the responsibility for the project lies with the executive, while management of funds belongs to the State Bank of Pakistan. Court ordered transfer of collected funds around PKR 23.67 billion to public accounts of the Federation, ensuring transparency and proper state oversight. In environment
separation of powers with the fundamental rights, which is fundamental to our constitutional framework, has been upheld. This approach reinforced the judiciary's role as an interpreter of law rather than the maker of law, which in turn had the effect of strengthening the pillars of our democracy. Your judgments in the cases like Faizabad Dharna highlighted your dedication to constitutional values, ensuring the protection of fundamental rights such as freedom of speech and expression, while also maintaining the importance of non-violence and peaceful assembly. Similarly, your meticulous handling of cases involving environmental protection, corruption and government accountability has showcased your vision for a Pakistan that upholds fairness, integrity and the rule of law. Additionally, your decision to definitively settle the issue of lifetime ban underscored your commitment to giving due weight to the actual text